Morning everybody, I'm Mark Hallam. I'm an IRLA board member, so it's my privilege and honour to welcome Mr. Kendall here today. So thanks ever so much for being here. I know there's lots of train troubles, parties last night, etc. So I think we're doing well to all be here. We will be having a few stragglers coming in, so I think it's about another 15 people we're expecting. So let's just try and help slip them in when they arrive. So we're basically here today. David's going to be talking to us about the 100 years law enters the 21st century. He's going to be very much focusing on the impact of the law, UK law reform on reinsurance and on the London market. So looking forward to this. I know it's a very, very important topic, and I know there'll be lots of questions coming out. First of all, housekeeping. By law, I have to tell you this. First bit I don't. Can you please put your mobile phones on silent? So we don't want any interruptions there. If you hear the fire alarm, I've been told it will be real. So we will be obviously evacuating, but hopefully that won't happen. Toilets are outside, hopefully you found those. So obviously if you need to get up, do, and help yourself to refreshments. There will be a survey at the end, a 2-minute survey, so please, if you could complete the survey, which we'll send out later today, as it really helps us basically plan future events. And last but not least, I've been asked by Leslie Ann to do a bit of a plug. There's a couple of events coming up next year. First of all, we've got the quiz night on 2nd of February, please look out for that. And secondly, on the 21st of March, we've got Crazy Golf at Swingers. Obviously, nothing like today's event, but please, please, please support, it'd be great. So, David Kendall. David's a partner at Cooley's London office, as you probably all know. He focuses on all aspects of insurance and reinsurance. He's the immediate past chairman of the British Insurance Law Association. And also, I was quite impressed when I was reading his CV. He's got many different accreditations, but a couple of notable ones. He's listed in 2 guides to the world's leading lawyers, with the best of the best 2016 insurance and reinsurance, noting David amongst the top 10 legal practitioners for the insurance industry in the UK, and one of the top 30 worldwide. Also, amongst other recognitions, he's also named as one of the top 6 insurance and reinsurance lawyers in Europe. So I think we're in great company today. So David, hopefully I'm doing you justice. So on that note, you don't want to listen to me. I'm going to pass over to David. We will have Q&A later on. He's also got a scenario if the questions run out. But we'll see how the sessions go, and please let's make it as interactive as we get into it. So thank you very much. Welcome, David.
Thank you very much, Mark. I'm going to sit and do this, if that's all right. As the title was intended to suggest, the Insurance Act 2015 is the first significant change to UK insurance law in over a century. And it is going to have a significant impact, I think, on the way in which the market underwrites insurance. And we're already seeing that. It came into force in August of this year, and those involved is all in the active market know that brokers are producing all sorts of clauses to try and address some of the issues that the Act raises. The Insurance Act follows 8 years of review and consultation by the Joint Law Commissions, so there's lots of background material to its introduction, but it still has some elements that are controversial and may well create some difficulties. I'm going to go through all the changes that the legislation introduces, but I'm going to focus in particular on its impact on reinsurance and on the London market. There are some parts of it which I'm going to skip through. It's all in the slides, so if you want to know a bit more about warranties, etc., it's there for you to review in detail. So very briefly, what is the new legislation that has this impact? Well, it's important to distinguish between consumer insurance, essentially personal lines, and that is governed in particular by a 2012 Act. It's also affected by the Insurance Act 2015 and also by the Enterprise Act 2016. The Enterprise Act introduced into English law the remedy of damages for late payment of an insurance claim. And that will come into force May next year, and we'll have a look at some of those provisions and how they will impact on insurers. And then for non-consumer insurance, which is essentially business insurance, the 2 relevant bits of legislation, the Insurance Act 2015 and the Enterprise Act. Just to look very briefly at the consumer insurance legislation. This is relevant to the London market because the London market now underwrites a lot of business through cover holders. and will be exposed to consumer insurance. So what is a consumer? It's an individual buying insurance wholly or mainly for purposes unrelated to the individual's trade, business or profession. So if Mr. Brown insures his house, that is consumer insurance. If he insures his shop, that is non-consumer or business insurance. There's no duty of disclosure now for a consumer buying insurance, so that's a significant change in the law. There's a duty on the consumer to take reasonable care not to make a misrepresentation to his insurer. So essentially a negligence standard is introduced. The Act introduces proportionate remedies if the consumer does make a misrepresentation to the insurer, and those proportionate remedies are very similar to the ones that have been introduced with business insurance, and I'll go through those in a bit more detail. There are something called basis clauses in insurance contracts. A basis clause converts a representation made by the policyholder into a warranty in the policy. Those are banned for consumer insurance, and we'll see they're also banned for business insurance, no longer enforceable. The insurers cannot contract out of the 2012 Act, and it applies to all insurance contracts entered into after the 6th of April 2013. Let me clarify here, because there's a bit of confusion about what this start date means. The 6th of April 2013 is not the date when the contract incepts, it's when the contract is underwritten by the insurer. So it's when the contract is entered into rather than when it incepts. And that is the same for business insurance as well. Okay, so what does the Insurance Act 2015 do? Well, it applies to all insurance and reinsurance contracts and any variations to those contracts that are entered into after the 12th of August this year. And again, it's entering into, it's not the date of inception, which triggers the application of the Act. It has a duty of fair presentation on the policyholder, so unlike consumer insurance, where there is no duty to disclose, the duty to disclose is kept in this duty of fair presentation. The remedies for breach of duty are going to be proportionate. So again, as with consumer insurance, it will no longer be the automatic remedy of avoidance of the contract ab initio, which was the position under the old law. The so-called basis of contract clauses are outlawed in business insurance as well as in consumer insurance. The remedies for breach of warranty are changed. Under the old law, if the policyholder is in breach of warranty, then the insurer was discharged from all liability under the policy for all time, and that could not be remedied. That has changed. Policyholders who are in breach of warranty can now remedy the breach. If they remedy the breach, the insurer is back on the risk. We'll have a look at an example of a warranty claim to see how that's going to work. And there's also a further change in the remedies for breach of warranty. Effectively, if the policyholder can establish that the loss that has occurred is not related to the breach of warranty, then the insurer will still have to cover that loss. That's quite a controversial area because the test is a bit convoluted. And again, we'll have a look at that and see how it works in practice. Remedies for fraudulent claims, well, that has now been set out in the Act. It probably follows the scheme that we assumed was positioned under the old law, though there was some doubt about that. Essentially, if the policyholder makes a fraudulent claim, not surprisingly, the insurer is not liable to pay the claim, but also the insurer will have a remedy to cancel the contract, cancel the policy from the time of the fraudulent act, which is relevant if there are more claims coming in from that policyholder post the fraud. And you may be aware there's been a very recent Supreme Court decision which affects what amounts to a fraudulent claim, and I'll say something about that. Contracting out, the insurers can contract out of the Insurance Act as regards business policyholders, except for basis of contract clauses. They are verboten. In contracting out, though, there are transparency requirements. You have to make sure the policyholder is aware of the contracting out provision and is also told what the effect of the provision is. So it's not simply saying Section 12 doesn't apply. You've got to explain what the consequences of that are. And then finally, as I said, the Enterprise Act 2016 amended the Insurance Act and introduced a remedy for late payment of an insurance claim. And that will apply to all contracts entered into on or after the 4th of May next year. Okay, so as I've said, the Insurance Act applies to contracts of reinsurance and retrocession. Essentially, it treats them as if they are non-consumer insurance contracts. They apply to all contracts and variations of contracts that are expressly or impliedly subject to UK law. And as you probably know, UK law is made up of a variety of different laws: Scottish law, Northern Irish law, but obviously includes English law. And as far as the London market reinsurance contracts are concerned, it's English law which we're going to be mainly concerned with. It's important to note that the contract applies where the Act applies where the contract is subject to English law. It doesn't matter where the contract is underwritten. So if the underwriter is sitting in Bermuda and writes a reinsurance of the London market that is subject to English law, it is the Act that will apply to the underwriting of that contract. If the underwriter is sitting in London and underwrites a contract that's subject to a US state law, the Act has no application. So although the Act will influence conduct of underwriting, it's important to recognise that it's the applicable law that drives whether the Act applies. It doesn't matter where the contract is entered into. Now, these days, the usual practice is to include a choice of law clause in commercial insurance contracts that will specify which law applies. If there isn't a choice of law clause, the usual rule is if the contract is broked in London or contains a London arbitration clause or a London High Court jurisdiction clause, then it is likely to be subject to English law. But if the contract provides that disputes are to be resolved outside the UK, it is probably unlikely that a French court or a New York court will apply English law. They're going to apply probably their local law in interpreting the contract, and in those circumstances the Act won't apply. One exception you have to be aware of is the exception for EU risks, so risks insuring a policyholder in the European Union or a risk that's based in the European Union. That is not a large risk. In simple terms, a large risk is what is either marine aviation or transport, or where the policyholder's balance sheet is greater than 16 million euros, or it has a turnover of 12 million euros, or it has 250 employees. If it's a large risk like that, then the choice of law clause will apply. So if you choose English law, that will apply. But if it's not a large risk, so if you're insuring an SME business in Europe, the choice of law clause will not apply. And generally, the law that will apply will be the law of the place where the policyholder has its business. And people need to be aware of that exception, because it can change your understanding of what exactly you've underwritten. Now, I said I'm going to talk a little bit about the London market. The London market involves a lot of delegated underwriting, whether that's through a cover holder, an MGA, a line slip. A line slip involves delegated underwriting. The line slip leader acts as agent for the market and underwriting risks. And broker facilities will also involve delegated underwriting. the Insurance Act doesn't apply to the agency contract. Because these agency relationships are contracts for insurance, they're not contracts of insurance. So the agency contract may be subject to English law, but the Insurance Act is not going to apply to the relationship between the insurer and the agent, the underwriting agent. But obviously, if the cover holder or the MGA is underwriting policies or issuing certificates of insurance that are subject to English law, then the Act is going to apply to those certificates and those policies. So what is this duty of fair presentation that the Insurance Act sets out? It's actually very, very similar to the old law. So the policyholder is under a duty to disclose material circumstances. Any representations that are made in the course of underwriting must be substantially correct, and any representation of expectation or belief, so if you give an EPI, that has to be given in good faith, which essentially means given honestly. Now there are two riders to this which may make a change to the old law. First of all, the policyholder will only make a fair presentation of the risk if the disclosure that is given is reasonably clear and accessible to a prudent insurer, which the Law Commission said was aimed at preventing data dumping. I think those who underwrite financial institutions risks or D&O policies quite often find the broker comes in with a stack of paper that's 2 feet high, including past accounts and 10Ks, etc., That is regarded as a data dump because the underwriter is clearly not in a position to plough through the 2 feet of paperwork. So the idea of this is to put some pressure on the brokers and the policyholders to make a fairly short, but not too short, presentation of the key features of the risks that the underwriter is being asked to underwrite.
So have these concepts ever been tested?
No, this is a new concept. I think it's fair to say it's a new concept. Of course, the difficulty is that if the broker pitches up with a foot high of paper and the underwriter decides to underwrite anyway, it will be said that he's waived this obligation to make a reasonably clear and accessible presentation. So where I think it's mostly going to come into play is where you get a 20-page placing memorandum, and in footnote 35 on page 19, a very significant piece of information is disclosed. Is that reasonably clear and accessible? So that's something which is in the favour of insurers, but the flip side is another variation that's been made, I think a variation to the old law, which is that it is a fair presentation of the risk if the underwriter is put on notice that he ought to be asking questions. And it's therefore for the underwriter to spot that there's something in the presentation which is a bit ambiguous, or there's something in the presentation that is missing, and to ask for that information to be provided. And the classic example would be if the broker comes in with a presentation but there's no information about past claims. And there's been quite a recent case where that happened, an AXA case where the court said that by not asking questions, effectively the underwriter waived the non-disclosure of past claims information. So what the Act does is it puts more emphasis on there being an exchange between underwriter and broker at the time of placing, and in particular puts more emphasis on the underwriter asking questions. Now if the underwriter asks questions, if he gets responses, those will be representations, and those representations must be substantially correct if it's to be a fair presentation. But of course the underwriter has to keep a record of what he's asked and the answers he's been given, because in 2 years' time, when there may be an issue about a material misrepresentation, it's no good the underwriter saying, I thought I asked about that, and I thought I got an answer, but I've got no record of it, because the underwriter's credibility may be difficult to sustain in the absence of a written record. And of course, it's no good keeping a record, keeping a note of what you've been told, if you can't find it 2 years later. So again, the emphasis is going to be on making sure that any record is stored somewhere where it can be found readily. It's also important to recognise that in the way in which business is placed in the London market, where a lot of reliance is placed on the underwriting decision by the leader, that representations made to the leader are not representations to the following market. So there may be a misrepresentation made to the leader, and the leader may have underwritten the contract based on that misrepresentation, and the leader may have a remedy for breach of the duty of fair presentation. But if the following market not asked the same question and not received the same misrepresentation, then they may have no remedy for a material misrepresentation that's been made to the leader.
Presumably that would be different, David, on a line slip where you've got the agency relationship.
That's right. On a line slip, the leader of the line slip is the one who makes the underwriting decision, and the following market is entitled to rely on the decisions made by the leader. That lacuna, well, it's always been there, that issue. As the Insurance Act has brought it more into focus, is being addressed in various ways. The LMA have put out standard clauses whereby the following market is going to be entitled to rely on any misrepresentation made to the leader. Not surprisingly, the brokers are pushing back and putting in clauses which say entirely the contrary. We have a soft market at the moment, and I think the brokers are winning in the battle with the clauses. Well, what is material information? Again, this is very, very similar to the old law. So material information is that which would influence the judgment of a prudent insurer or reinsurer on whether to underwrite the contract, and if so, on what terms. And examples of material information are given in the Act. So if it's special or unusual facts relating to the risk, that is material, should be disclosed. If the policyholder has any particular concerns which has led them to buying the insurance or perhaps purchasing additional limits, the Act says that that is material information. That may well be a change from the old law, where I'm not sure that the reasons why the policyholder is buying insurance was something which was necessarily material. And then also, by focusing on particular classes of business, if in a particular class of business, underwriters would normally expect information to be given, then that information probably is material and has to be provided as well. Okay, now disclosure of information depends on what the policyholder...
Sorry, excuse me, I wasn't sure if you're going to come on to it.
Yeah.
Forgive me for not knowing the Act better, but in the previous law there was something about material information only, information only being material if it increased the risk, and there wasn't an obligation to disclose information which didn't increase the risk, I think. Am I right?
That's still the position.
That's still the
yes.
position.
Yeah. Thank you. Okay, so disclosure depends on knowledge. Now we all know what we know. So if we go and buy our car insurance, we presumably would know that last year we dinged our car and we ought to disclose that if we're asked. But a company is not an individual, doesn't actually have a memory. So the issue for a company is what counts as its knowledge for disclosure. And the Act throws out the old law and introduces a new scheme of knowledge. So if you are an individual and within a company, the knowledge of the individual is disclosable if the individual is part of the senior management of the company. And the knowledge of those who are responsible for procuring the insurance also counts as the knowledge of the company. So what they know is disclosable. The definition of senior management is those who play significant roles in the making of decisions about how the reinsured's activities are to be managed or organised. Which is quite a mouthful. The Law Commissions published a report in July 2014, and they said they thought that meant it was limited to directors of the company. And when this legislation went through the House of Lords, one of the people sitting on the Special Bills Committee was a non-executive director of the Royal Bank of Scotland, and she said, as a director, I know nothing about the bank's insurance arrangements. How could it possibly be limited to knowledge of directors? The government sort of acknowledged that that was a good point, because obviously in a large organisation, knowledge about matters that are relevant to insurance are unlikely to be held at director level. They're going to be held at a sort of a management level. So the government issued explanatory notes about the legislation, and they said it may or may not be limited to directors, which doesn't help a great deal. It is important because if you are a member of senior management, your knowledge is disclosable, whether or not you're asked. What about individuals responsible for procuring the insurance or the reinsurance? Well, again, the focus is on individuals. So looking at a corporate, that's likely to be the risk manager, because the risk manager is going to be involved in buying the insurance. If you're looking at a reinsured, it's likely to be the reinsurance manager. It's not likely to be an underwriter, unless the underwriter is buying facultative insurance. An underwriter may not fall into the category of senior management. So there's a sort of a gap there, which I think reinsurers are beginning to recognise, and perhaps you may see requests for information from others than the reinsurance manager or directors of the reinsured. This definition also picks up the broker, but it's the individual broker involved in broking the insurance. It's not the broker's organisation, because the focus is on individuals. If the business is being placed through a chain of brokers, through a retail and wholesale broker, it will be the individuals in those organisations whose knowledge is disclosable. It's not the organisation itself. There is one carve-out on what counts as knowledge that was put in specifically for brokers. And that deals with information that a broker acquires from someone other than the policyholder. Because it is said, well, if that is acquired in a confidential relationship between a client and the broker, that information is not disclosable, even though the individual broker knows it. The business has to be acquired through a business relationship. So it's not good enough if your neighbour over Christmas drinks gives you a piece of important information. There has to be a business relationship, so a client relationship with the broker. The dilemma that this places the broker in is the broker has to assess whether the piece of information, which may be highly material to the risk that he's about to place, was received in confidence through a business relationship. Because if it wasn't, then it's disclosable. And if it's not disclosed, there'll be a breach of the duty of fair presentation, and the underwriter would have remedies for that breach. The view is that whether or not the information is confidential probably has to be assessed on some objective basis. So it's not good enough for the broker to say, well, I thought that I had that information confidentially. There has to be an objective assessment of whether it truly was given to the broker in a confidential way.
Can I just clarify that? Do you think that if the broker does pick up something over a boozy Christmas lunch, not in a business context, that is therefore disclosable, because it's not a confidential business?
It's not a business relationship. The requirement in the Act is that it should be acquired through a business relationship.
It's a different question about whether it will remember it out of it.
Yes, indeed. And of course the other difficulty for the broker as well is that if the broker has this piece of highly material information in his head, and he goes and brokes to the underwriter, his relationship with that underwriter may be fatally undermined if the underwriter subsequently discovers that the broker knew something, the ship had sunk, at the time of placing, but has somehow wriggled out of the obligation to disclose it because, oh, I got it in a business relationship, it's confidential. And I think the sensible broker will actually make sure that whatever information he's received, he can pass on to his policyholder, so if the policyholder makes the decision about whether or not you're going to disclose it, and of course if he passes it on, the policyholder probably does have to disclose it. Okay, so that's one aspect of what counts as a company's knowledge, what is known by these categories of individuals. The second category is an entirely new category, and it is knowledge that would be revealed by a reasonable search carried out by the insured of information held within the insured's organisation or by any other person, specifically including an agent of the insured or a covered person. What is a covered person? Well, if you look at commercial insurance, quite often the policyholder will be the holding company or the active company engaged in the business. And you'll quite often see that there are others who are insured under the same policy. So you might see for a large corporation a schedule listing 500 subsidiaries which are also insured under the policy. If you buy a D&O policy, you'll have a whole list of either identified or specified directors and officers, or even staff who are insured by the policy. Those policies are usually, I think, a contract between the insurer and the named policyholder. And it is the named policyholder, the entity entering into the contract of insurance, has this duty of disclosure. If you get the benefit of the insurance, you may be entitled to enforce your benefits under the policy, under the Contracts, Rights of Third Parties Act, but you're not actually a contracting party. And therefore you're under no duty to disclose, because the duty of disclosure is on those who are contracting with the insurers. What the reasonable search requirement recognises is that the insured needs to ask these people whether they have any relevant information. So they need to be the subject of the reasonable search. Now this is an entirely new concept. It wasn't a concept under the old law. So what is meant by a reasonable search? What do you have to do as a policyholder to gather information? The Act doesn't really give much guidance, and the Commission doesn't. The law commissions don't really give much guidance in their reports. It seems to me that you have to look at what is the reason for carrying out the search. Well, the reason for carrying out the search is to gather in information that's going to be material to the contract that's being placed. Whether something is material depends on whether an underwriter considers it to be material. So the insured, quite properly, will be looking to its broker as the insurance professional to advise it on what information it should be searching for in order to make this fair presentation. It has to be a reasonable search, so you're not expecting the policyholder to go and trawl through its archives. It has to be information that's reasonably available to the policyholder. What's meant by organisation? Is it limited to the individual company that's buying the insurance, or does the company have to look beyond its own corporate self into the organisation as a whole? And the classic example of where this becomes an issue is if you are a captive buying reinsurance. Do you have to search just within your captive organisation? So what information have you gathered in from your corporate insureds over a period of time? Or does this mean you actually now have to go out to your corporate insureds within your organisation and ask them whether they have any relevant information that's now to be put together in the package to be presented to your reinsurers? Are there any limits to what is meant by any other person? Because the reasonable search has to include any other person. The law commissions in their report said, well, actually this could be anyone. You might have to ask your accountants, you might have to ask your lawyers, you might have to ask your suppliers. That, I think, simply goes too far. I can't imagine that any court's going to say that Tesco will be expected to ask all of its suppliers whether they have any relevant information for the purposes of the placing of Tesco's liability insurance. Are you supplying the horse meat or beef this week? But there is uncertainty about what the scope of that is and exactly who falls within any other persons that you have to ask for information.
Could the parties to the contracts contractually define these terms?
Yes.
You can do that. So,
yeah, it's important to recognise that this deals with setting the general parameters of what an insurance contract requires. Because it's a contract, there's no reason why the parties can't agree otherwise, subject to the limitations on contracting out for insurers, which we'll have a quick look at. And as Philip has quite rightly identified, the brokers probably quite rightly are concerned about the breadth of this, the scope of this, the uncertainty about this, and are addressing it in clauses in contracts post-August this year. One issue would be, well, you can ask anyone you want for information, but you may not be legally entitled to have that information. So if you are a principal, you are entitled to ask your agent for information. Your agent's probably under a legal obligation to give you that information. A supplier is probably not under a legal obligation to give Tesco information. Does that make any difference? We don't know. Another issue is, when should the search be conducted? When the insurance bill first came out, the brokers were being advised and were advising their clients that they needed to think about this reasonable search and perhaps starting the search 6 months before their policies were due for renewal, to give them ample time to gather in the information and present it. But the duty to make the fair presentation runs right up to the point when the contract is underwritten. So if the information is gathered 3 months, 2 months before the contract is placed, and something significant happens in that 2-month period that ought to be disclosed, but isn't included because the reasonable search didn't elicit that piece of information, is the search a reasonable one? Is the presentation a fair one? And again, the Act doesn't give you any answers to that question.
But, David, I'm not sure this is quite the monster which a number of people have suggested it might be, because under the old regime, where you had plain vanilla duty to disclose material facts, your position was worse than under the regime which has been introduced. But I mean, even many years ago, when I was buying for a big professional indemnity program for a far-flung group, we had a process written into the policy as to what we would do in order to satisfy the duty of disclosure under the program, in terms of timings and disclosures and who we were approaching and how we were getting the information, and particularly because claims and circumstances are no respecters of renewal dates, what we did if we had a late notified claim of whatever scale it might be.
Yeah.
And we had quite a precise process written around this in order to protect the organisation from what was the very onerous duty to disclose material facts under the old regime. So, I mean, if this is prompting people to copy what in my head is actually quite an old practice with big organisations, I think that's quite a good thing. I don't see it as a negative.
Well, what you described was very common, and no doubt still is common, for financial institutions and a lot of professional indemnity insurers. You quite often see clauses that dealt with this issue of duty of disclosure and the gathering of information. But I think beyond that, with ordinary manufacturing organisations or SMEs who don't have that level of sophistication or appreciate the issues, you tended not to see those sorts of clauses. I think that has now changed, because I think brokers have become much more alive to what the law requires, and so that's why we're seeing more clauses in more classes of business. For instance, I think in marine insurance, we would very rarely see a clause that address duties of disclosure, consequences of misrepresentation. I think now, as I understand it, the marine market is now more usual since August for brokers to be coming out with clauses which attempt to address these concerns. But the difficulty is that some of the clauses that are being produced almost eradicate any duty of disclosure. I mean, essentially almost eradicating it so that in some clauses, even if there was fraud, deliberate misrepresentation, the underwriter might have a remedy. Now, actually, as a matter of English law, you probably can't do that, because as a matter of public policy, you cannot contract out of fraud in arranging a contract.
Until the Supreme Court says you can.
Yeah. Well, it was a House of Lords case which said that, although there is uncertainty about whether you can contract out of your agent's dishonesty. But obviously there's some concern in the market that this is actually going too far, because the market works on the assumption that there is a fair presentation of the risk, and the underwriter is underwriting on that basis. If there are now clauses which effectively say, well, you cannot assume that you're receiving all material information, and if you don't receive the material information, you may have no remedy. That shifts the balance and the assumptions being made in underwriting. And I think the LLA put out a market bulletin, possibly last week, warning underwriters about the risks of these sorts of clauses. So that deals with what has to be disclosed by the policyholder, but obviously disclosure means telling the underwriter something that he or she doesn't already know. And so what the underwriter knows, what the insurer knows, is relevant. And again, the Act sets up a scheme of identifying what counts as the knowledge of an insurer, because an insurer obviously mainly is going to be a corporation. And the test is different from that which applies to policyholders. So the Act sets out that there's no obligation to disclose something if the insurer knows it, ought to know it, or is presumed to know it. So knows means actual knowledge. What counts as the actual knowledge of an insurer or reinsurer? Well, the Act says that the insurer only knows that which is known by the individuals who participate in the decision to underwrite the risk, which obviously means the actual underwriter, and probably includes members of the underwriter's team to the extent they're involved in assessing the risk that's to be underwritten. That and only that counts as the knowledge of the insurer. So if you're looking at a cover holder relationship, it is the knowledge of the underwriter at the cover holder, which is the knowledge of the insurer, not the person at the insurer who may have made a decision to appoint the cover holder, because that person will not be involved in the decision to accept a particular risk, which means that the insurer is reliant on the conduct of the underwriter and the knowledge of the underwriter at the agency or at the cover holder. What ought an insurer or a reinsurer to know? Well, this introduces a category of persons who are employees or agents of the insurer who should have told the underwriter relevant information. And it also includes information that is held by the insurer which is readily available to the underwriter. So if claims information is readily available to the underwriter, available on intranet online, but the underwriter for some reason doesn't look at that claims information when renewing the risk, he will be deemed to know what was in that information. Now it's important that the Act says it's information that is held within the insurance company, because the suggestion was, well, you could then expect the underwriter to go online and Google and see what information is available on the internet about the insured. The Act doesn't expect that to be done, doesn't require that to be done, so if information is available on the internet, that's not deemed to be the knowledge of the underwriter. It is only information held within the underwriter's organisation that is going to be available, but it has to be readily available. So there may well be questions that come up about whether a particular piece of information held within the claims department was readily available to the underwriter and his team at the point when they're underwriting the risk. And then finally, what is an insurer presumed to know? Well, this reflects the old law. They're expected to know things which are common knowledge. So they're expected to know there's a civil war in Syria. And they're expected to know that which in the ordinary course of business they're expected to know about. Now there is some uncertainty about that, because under the old law there were cases which went either way on whether, for instance, an underwriter was expected to know, presumed to know, information that was in Lloyd's list about a casualty, for example. In one case the court said the underwriter is presumed to know that which he or she should have read about in Lloyd's list that day, and therefore knew about a particular casualty, even though on that day he hadn't actually looked in Lloyd's list. Other cases have said, no, you can't expect the underwriter to be consulting newspapers and to know that level of granular detail. Something of major significance happening in the world, yes, expected to know that, but not something of greater particularity. What are the remedies? Well, you have to show reliance on the breach. You can avoid if the misrepresentation was deliberate or reckless, or the non-disclosure was deliberate or reckless. If it's not deliberate or reckless, then the insurer can avoid if the underwriter says, I would not have touched that risk had I been given that information. If the underwriter says, well, I would have written the risk, but I'd have put an exclusion in, if that evidence is accepted, then the exclusion will be deemed incorporated in the contract. Whether it matters, of course, will depend on what the claim is. If the underwriter says, I'd have charged a higher premium, the remedy there is to reduce the claims proportionate to the amount of additional premium. So if the underwriter says, I'd have charged 50% more, the claim gets halved. But it does depend on there being a claim. If there's no claim, then the underwriter has no remedy if he would have simply charged more premium had there been disclosure. So impact on underwriting, representations become much, in my view, much more important, because you avoid all these uncertainties about what counts as the insurer's knowledge. The underwriter asks the question, gets a representation, that then counts as the record of the presentation. Underwriters need probably to use more application forms and questionnaires to make sure that questions are asked and answered, keep a record of the questions and the representations. What information is available to the underwriter? Well, obviously that varies over time, and I think one of the things that compliance departments have to think about is maintaining a record of what information is available to underwriters from time to time, so if the question comes up, they can say, well, on that date, we didn't have access to that particular database. And because the remedy for the breach of duty of fair presentation is all going to turn on what the underwriter would have done had the truth been told, inevitably there's going to be issues about what the approach to underwriting was of that underwriter. So I think manuals, guidelines, possibly risks previously underwritten by that underwriter, possibly even risks declined by that underwriter, may all become relevant to assessing the evidence given by the underwriter about what he or she would have done. Now, under the old law, the court said, we're not interested in looking at that sort of information. There, the test was solely whether the underwriter had relied on replacing information or not. But the Act takes us beyond that. It says, what would the underwriter have done had the presentation been true? And that, I think, opens the door to looking at what the underwriter has done otherwise. I'm going to skip through some of this. Basically, the contract clause is outlawed. It's in the slide. Warranties, as I've said, there's a change now in the law on the effect of breach of warranty. The breach suspends cover during the period of breach. Once remedied, the insurers are back on risk. I'll look at a case to explain how that works. So these are slides on warranties, all there for you to look at. Section 11, which is so-called risk mitigation terms, which is probably going to apply largely to warranties rather than any other term of the contract. I'll just read this, and it shows how convoluted it is. So unless the term in the contract defines the risk as a whole, and there's some uncertainty about what terms define a risk as a whole, but if it's not one of those sorts of terms, if compliance with the term would reduce loss of a particular kind or at a particular location or time, then the insurer or reinsurer may not rely on the breach of the term if the reinsurer shows that non-compliance could not have increased the risk of loss that occurred in the circumstances in which it occurred. And a lot of people have described that as a recipe for litigation. It's certainly a bit confusing just to read it. Let me give you a quick example of how it's going to work, and it comes from an actual case, Sugar Hut and Great Lakes. Apparently Sugar Hut, well, I don't know this person, is a chain of restaurants and nightclubs in Essex. Some of you may have been to a Sugar Hut nightclub. They had insurance with Great Lakes, property insurance. There was a warranty in that property insurance that they would maintain a working burglar alarm at all times. There was, I think, the equivalent of a chip pan fire in a kitchen at one of the Sugar Hut restaurants, and it burnt down. So they had a claim under their property insurance for the loss of their restaurant. And Great Lakes said you did not have a working burglar alarm, you were in breach of warranty, and under the old law that means that we are discharged of all liability. And so they were entitled to decline the claim. Now under the new law, if there was a burglar alarm that wasn't working, then the Great Lakes would be off risk during the period that it wasn't working. So if Sugar Hut fixed the burglar alarm before the chip pan fire, then the insurance would have to respond to the loss, unlike the old law. But how would Section 11 apply in these circumstances? So the burglar alarm warranty is there to reduce loss of a particular kind, theft from the restaurant. So it falls within Section 11, doesn't define the risk as a whole. So Sugar Hut would say the burning down of our restaurant had absolutely nothing to do with the fact that the burglar alarm wasn't working. To which the insurer says, but if the burglar alarm had been working, the fire would have set it off, and the emergency services would have been there 15 minutes earlier than they were, and the damage would not have been as great as it was. And it therefore increased the loss, the risk of the loss that occurred. And in almost every scenario that you can come up with to illustrate this point, you can see the arguments on both sides. And that is why it's a recipe for litigation. Fraudulent claims, I think I've dealt with that. The pursuit dredging case says that it is not a fraudulent claim if the policyholder tells a lie during the course of presenting his claim, provided the lie does not affect the validity or value of the claim. Which in some circumstances is a fair result, but in other circumstances is to be doubted. But that is now the law. So if the policyholder says that it did something in order to accelerate payment or decision about payment of the claim, but that doesn't affect the value of the claim, then it is not a fraudulent claim and the insurer has to pay. I'm conscious of the time, so I'm going to skip through late payment of insurance claims. That's going to come in all contracts entered into after the 4th of May 2017, including contracts of reinsurance. So reinsurers may be liable in damages for late payment of the claim. What the Act does is it introduces into every contract of insurance and reinsurance a new implied term. So it is a term of the contract that the insurer or reinsurer must pay a sum due in respect of a claim within a reasonable time. And what is a reasonable time depends on all the circumstances, but the Act recognises that the insurer or reinsurer has to have a reasonable time to investigate and assess the claim. The Act gives particular examples of things that the court has to take into account. So the type of insurance. So the amount of time taken to assess a motor claim is presumably going to be less than the amount of time taken to assess a business interruption claim. And again, the size and complexity of the claim is taken into account. There's been a couple of fairly recent cases looking at what is a reasonable time to assess the claim, and that's been in the context of the old law and whether an insurer had waived its right to avoid through the time it took to assess the claim. One of those was a motor claim, where the court said that 2 months to assess a motor claim was reasonable, given that the 2 months included Christmas. So if you take Christmas out, maybe 6 weeks. For a more complex construction claim, the court said that 6 months was a reasonable time taken by the insurer to assess the claim. So there's some sort of guidelines there as to the time taken. One important matter is that the court will take into account compliance with statutory and regulatory rules. And I've set out in some of the slides some of those rules which the court is probably going to take into account. So it now becomes, in a way, more important than ever for insurers and third-party agents and cover holders to comply with FCA, ICOB's, Lloyd's rules and guidance, because they will be taken into account in assessing whether the claim has been assessed in a reasonable time. Factors outside the insurer's control taken into account. Obviously, if the insured is difficult, doesn't provide information, etc., that's going to be taken into account. One of the more questionable areas, though, is if the insurer doesn't have enough staff to handle the claims in a reasonable time. That may be due to sickness, may be due to difficulty in recruiting staff, may be due to the fact that there's suddenly been a flood of claims as a result of a flood. Now, the regulatory guidelines say that insurers have to plan for those sorts of circumstances. So that is something which a court may take into account if an insurer has taken 12 months to settle a flood claim because they don't have the staff to deal with the claims. I'm going to skip through, I say in the slides, I've got set out some of the relevant statutory or regulatory rules or guidance. ICOBS provides that you have to provide reasonable guidance to your policyholder to make a claim, so that's going to be taken into account. And you have to provide information on the progress of the claim as well. Settle claims promptly. I've also set out some of the Lloyd's minimum standards as well, which are going to be taken into account. Now, the really difficult area here is not so much did you take a reasonable time or not, it's going to be whether the policyholders are going to be able to claim damages for the late payment of the claim. And the reason this is difficult is that what the Act does is it implies a term into the insurance contract. So if the claim is not paid in a reasonable time, the insurer is in breach of contract. So what are the remedies for breach of contract? Well, the starting point, that damages for breach must be foreseeable to be recoverable. And that goes back to a case in 1854, Hadley and Baxendale. And what Hadley and Baxendale said is that a loss can be fairly and reasonably considered to be foreseeable if it arose naturally according to the normal course of things, or from special circumstances communicated, in this case to the insurer or reinsurer, at the time of contracting. The insured is also under an obligation to take reasonable steps to mitigate the loss. So what are the sorts of damages which a policyholder may suffer as a result of late payment of a claim? Well, the obvious one is loss of interest on the amount that would have been paid to him on time. And there's no doubt that interest, and in fact compound interest, is recoverable for breach of contract. And there's an insurance case, Equitas and Walsh and Brothers, quite recently, where the court said, almost self-evidently, you'll be entitled to recover compound interest for late payment of a claim or a debt. So no problem with that. But what happens if the insured says, my factory burnt down, I couldn't raise the funds from the bank, because no bank would lend to me to rebuild my factory. So as a result, I was out of business for the 4 years that it took this insurer to assess and pay the claim. And those are the facts in Sprung and Royal Insurance. Is the insurer going to be able to recover all the profits that it would have made had the claim been paid 3 years earlier? Now, as a general matter, under the old law, impecuniosity of the contracting party was not a factor taken into account, or that could be taken into account in assessing damages. So in other words, it was not foreseeable that your contracting party would not be able to raise funds elsewhere to replace the money that you should have paid. There's been a very recent case, Lagdon and O'Connor, well perhaps not that recent, 2003, which was a claim in tort, and the assessment of damages in tort is different from the assessment of damages in contract, where the House of Lords said that impecuniosity of the counterparty is something which actually you could take into account. So if the counterparty didn't have access to funds, they're entitled to all the damages that would flow from not having access to funds. We don't know whether that's the position that's going to be taken in relation to the late payment of damages, the late payment of the claim. And I think that it's probably going to come down to what the insurer understood the position of the policyholder to be at the time of underwriting. So if the insurer knew that it was underwriting a small business, a guy who owned one factory, unlikely to be able to raise funds if that factory burned down, then the loss resulting from the burning down of the factory and the delay in paying was probably foreseeable. But if you're insuring Shell, nobody's going to say it would be reasonably foreseeable that Shell would not be able to raise funds to replace the asset that's been lost. And so it's going to depend, I think, on what is said of underwriting and what the underwriter assumes. The biggest risk is probably the one-ship company. If the one-ship company if the ship sinks, the one-ship company will say, I've got no means to replace that vessel. Inevitably, with sinking, there's suspicions of scuttling, and so settling the claim may take some time. If the claim is eventually found to be valid, the one-ship company may say, I've lost all the profits I would have earned from all the charter parties I would have entered into had you paid out my claim on a timely basis.
Presumably in that situation you wouldn't look past the one-ship company to the group.
Well, you could do. You could do. It all depends on what evidence is given by the owners.
Do you think insurers will try and pass those losses on to their reinsurers?
Okay, well, I'm going to skip through because I realise it's 10 o'clock. Let's look at the position of reinsurers. Okay? This implied term is a term of the contract. If the reinsurance covers the reinsured in respect of its liabilities under its contracts of insurance, then the reinsurer is picking up the liability for damages for late payment of the claim. And most reinsurance contracts will probably pick up that liability. I've set out there some typical reinsuring clauses, but I think in most cases you'd say, well, they pick up the liability of the insurer under his contract of insurance, and this is a contractual liability. This is not extra contractual. So an extra contractual obligation exclusion is probably not going to bite unless it gets varied to pick up the exposure to damages for late payment. But it's important to realise that the insurer's liability for late payment is not limited by the limits of his contract. There is unlimited liability for late payment. The reinsurer, in respect of that liability, is going to be able to rely on its limits of its reinsurers. So it is not, again, open-ended. One more point that's been raised, claims control. What happens if the reinsurer has claims control over the reinsured, and it's the reinsurer's decision not to pay the claim that has resulted in a claim against the reinsured for damages for late payment? Is the reinsurer liable to indemnify the reinsured for those damages? And the answer under usual policy terms is no, because the reinsurer under these claims control clauses is generally not limited to having to act reasonably, has to act in good faith, but not to acting reasonably. So if they decide in good faith we're not going to have that claim paid, the reinsured ends up paying damages. If the reinsurance covers the liability under contract, then the reinsurer will be liable up to the limits of the reinsurers, not to the ultimate damages which the reinsurer may have to pay. So again, that's an issue which in reinsurance terms is having to be addressed by reinsurers and reinsurers, particularly reinsurers who don't want to pick up liability damages for their pay. Tracting out, as I've said, transparency. I've set out in the slide some of the issues that arise for binding authority and TPA agreements. And here are the conclusions. If you underwrite for a cover holder or a TPA, you're going to end up being liable for what the cover holder or TPA does in relation to handling claims. But they probably owe duty of care to you. If they breach the duty of care, if they don't ask questions on underwriting, if they pay a claim late. We haven't gone into the operation of the subscription market. There are real issues there when it comes to damages for late payment of claims, because certainly under the Lloyd's claim scheme, it is the leader who handles the claim and makes decisions. If the leader screws up and there is a claim for damages for late payment, the following market will probably be liable for those damages. It will probably have a claim against the leader for breach of duty in handling the claim, and within the Lloyd's claim scheme there's a mechanism by which the leader may be liable to indemnify the followers in those circumstances. I don't think we have time for I'm sorry about that.
Any quick questions before we wrap up?
We've been asking good questions as we go.
Yeah, I think it's been good interactive sessions. Well, I mean, thanks, David. Thank you, Daniel, for coming, and look forward to seeing you next time. Thank you.